You may be seated.
All right, we're back on the record. Mr. Adams, I'm not sure if your lawyer has advised you what we discussed, but in this information, it's alleged that you were previously convicted of a felony theft offense in case 24 CR 1004 within the past 3 years. And first of all, just because it's got the 24 case number, I mean, it could have happened 10 years ago and just get indicted in 24, so that wouldn't, you need to include that language for the future. The case number itself wouldn't save the day there because it could be more than 3 years old.
Yes, sir.
But regardless, this isn't you. There's another Richard Adams across the hall who this case refers to. Now, you may have another prior felony theft conviction in 3 years, but it's not being alleged here, so that, and what's alleged here isn't you. So that language is being deleted. However, it's more than $1,000, which still makes it a felony, but it's a felony of the 5th degree based on it being over $1,000 instead of a felony of the 4th degree based on having a prior felony theft offense conviction. So this was discussed in chambers. I believe the state's moving to amend this information to reflect that. Is that correct, Ms. Johnson?
That's correct, Your Honor.
And no objection then, Mr. Mulkey?
None, Your Honor. I did explain this to my client as well. Thank you.
All right, so the court's going to delete the second paragraph dealing with the prior conviction as it's not this defendant. And we're going to add language that the value of the property involved is more than $1,000, which makes this offense theft, not grand theft, but theft, a felony of the 5th degree. So that's what you'll be pleading guilty to in this case. You understand that?
Yes, sir.
Any questions about that?
No, sir.
And so I'm going to read this to you now, the specific charges as amended. So what's alleged here, Mr. Adams, what you'll be pleading guilty to is on or about February 24th, 2025 in Lake County, Ohio, that you did with purpose to deprive Dustin, I'll spell his last name, I'm not sure how to pronounce it, Allgyre, the owner of property being $4,500 of U.S. currency, that you knowingly obtained or exerted control over that property by deception. The value of the property involved is more than $1,000, which makes the offense theft, a felony of the 5th degree. Do you understand what you're charged with and actually pleading guilty to in this information?
Yes, sir.
Any questions for
No,
me?
sir.
Okay. I sort of went out of order here, so I'm going to back up, but I'll skip that and get to it again. So before I can accept your plea to that charge I just read to you, I need to make sure you understand everything's going on, what your rights are, what the potential penalties you face are. So I'm going to ask you a series of questions. If at any point when you are going through these questions, if you have any questions for me, if you need anything repeated or clarified, and make sure you ask me that because I need to make sure you understand everything going on, all right?
Yes, sir.
All right. Let's get started then. How old are you, sir?
48.
Are you able to read and write the English language?
Yes, sir.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, sir.
Are you a U.S. citizen?
Yes, sir.
Now, before coming into court here today, have you any drugs or alcohol of any kind?
Nope.
What about within the last 48 hours?
No, sir.
Not even prescribed medication, nothing?
Nothing.
Now, did you receive a copy of this information? That
Yes.
was just when we just amended?
Yes.
Okay. And I just read it to you. You understand what it is you're charged with now as it's amended?
Yes, sir.
Any questions for me?
No, sir.
Well, then before I can accept your plea, I need to make sure you understand all the rights you're giving up by pleading guilty to this information. You, first of all, have the right to have this case presented to a grand jury. So what a grand jury is, it's made up of a group of citizens here from Lake County that get together and they meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether a probable cause exists that someone committed a crime. Probable cause is defined as some evidence that would suggest a person probably committed a criminal offense. Everyone in the state of Ohio here accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision as to whether someone should be charged or not. And you have that right as well, but you can give up that right if you desire and go forward in the charge brought by the prosecutor in this information as amended, and it's my understanding that's what you want to do here. Is that correct?
Yes, sir.
Well, before I can accept your plea, I need to make sure you acknowledge that here in open court in writing. I'm gonna sneeze. All right, I'm sorry, excuse me. So I have with me right here a one-page document called the Waiver of Indictment, which sets forth everything we've just discussed about this grand jury and that you want to give up that right. Before I can go any further, I need to be assured you understand this document and that you sign it here in open court. Now, my understanding is that before I came out here, you had a chance to go over this document with your lawyer. Is that correct?
Yes, sir.
I'm going to hand it back to you because I made some changes to it to reflect the amendment. Mr. Shadow? The amendment that was made because the offense is theft, not grand theft, and it's a felony in the 5th degree instead of a felony in the 4th degree. You can see where I made those changes there. I want you to initial that.
Sure. Just initial. This is yours. Put your initial above the card. All right. Thank you.
So you've read this document, Mr. Adams?
Yes, sir.
Any questions for me about what it says?
No, sir.
You understand what it says?
Yes.
And it appears you signed it. Did you sign it?
Yes.
Mr. Mulkey, you witnessed that?
I did.
Ms. Johnson, you as well?
I did.
All right, this document will be made part of the record. At this point, Mr. Adams, I need to review with you all the other rights you have that you're giving up by pleading guilty. And you first of all have a right to a trial. Trial could be to me as a judge where I listen to all the evidence and make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial, which would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and the jurors would make that ultimate decision. And that ultimate decision reached by those 12 jurors would have to be unanimous. Unanimous means all 12 of them would have to agree together, one way or the other, whether you're guilty or not guilty. Do you understand that?
Yes, sir.
Do you understand by pleading guilty, you're giving up your right to have a trial?
Yes.
Now, if we had a trial, the prosecutor here would be representing the state of Ohio. She would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. Your presumed innocence of this charge, the presumption of innocence, sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, sir.
Now, I speak of this burden of proof since this is a criminal case. That burden is what we refer to as proof beyond a reasonable doubt. It's the highest burden of proof there is in our justice system. And what it means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or part of this charge I read to you as amended beyond any reasonable doubt before you could ever be found guilty of this charge at a trial. Do you understand that?
Yes, sir.
You understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, sir.
Now, in order to do that, or at least in order to try to do that, if we had a trial, the prosecutor would be calling witnesses to come to court to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions. That's called cross-examination. He can ask them anything he wanted to within certain rules. Do you understand that?
Yes, sir.
You understand by pleading guilty, you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, sir.
Now, you'd also have the right to call your own witnesses to come to court and testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that, but you have a right to do that if you want to. Do you understand that?
Yes, sir.
And you further can request the court issue an order. That order is called a subpoena. What a subpoena would do is it would force or make someone come to court to testify for you and answer your lawyer's questions if they weren't willing to come in voluntarily on their own. You understand that?
Yes.
Do you realize you're giving up that right?
Yes, sir.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision. That is a choice that you and you alone have to make. Do you understand that?
Yes, sir.
And since that's your choice, what that really means then is that nobody else can force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But most importantly, the prosecutor here is not allowed to call you as a witness, make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you don't want to. Do you understand that?
Yes, sir.
You further understand that if we went to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to another court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes, sir.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, sir.
You still want to plead guilty?
Yes, sir.
You understand a guilty plea is a complete admission of guilt. That means you're admitting to the facts being alleged by the prosecutor. We're not going to argue that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, sir.
Further, as a result of pleading guilty, the effect of that plea is you'll be found guilty by the court, and then you will subsequently be sentenced by the court. Do you understand that?
Yes, sir.
Now, as far as sentencing goes, in this new case, as amended, it's a felony of the 5th degree that carries with it a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes, sir.
Now, are you currently on probation or parole to any other courts or agencies?
No, sir.
Obviously, you have the other case pending in this court, but any other cases pending against you?
No, sir.
Are you serving a sentence right now?
No, sir.
So, in this case, when we proceed to sentencing, I'll be sentencing you on this case along with the other case. I need to advise you that I do have the discretion if a prison term is imposed, and in each case, to run the prison terms concurrent or consecutive to each other. Concurrent means together at the same time. Consecutive means one after the other. You'd serve the prison term in one of the cases, complete that, then serve the prison term in the other case. You understand the difference there?
Yes, sir.
So in the other case, you're looking at a potential maximum prison sentence of 2 years. In this case, it's 1 year, so altogether with both cases, it could be 3 years. You understand that?
Yes, sir.
Now, if a prison term is imposed, in this case, upon your release from prison, you could be placed on what is called post-release control, sometimes referred to as parole. It's a period of supervision you would be on after you completed the prison sentence. And in this particular case, it could be up to 2 years. You understand that?
Yes, sir.
And if you were put on post-release control and ever violated any of the conditions of your post-release control, the parole authority could return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by this court. Do you understand that?
Yes, sir.
1 second. Now, aside from the possible prison sentence I just mentioned to you, there's other sanctions that could be ordered. You could be fined in this case up to $2,500. You can also be ordered to pay court costs. You can also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment, if any that were applicable. Do you understand that?
Yes, sir.
You can also be ordered to pay restitution to the victim for whatever economic loss the victim may have suffered as a result of your conduct. Do you understand that?
Yes, sir.
Now, a few moments ago, I explained the possible prison sentence you face. I did use the word possible because prison is not mandatory with this charge. You are eligible for probation, or what we refer to as community control sanctions. Do you understand that?
Yes, sir.
Do you understand that just because you're eligible doesn't mean you're automatically going to be put on probation? It means I would consider that if that's what you were requesting. I'm going to look at all the information that gets presented, then I'd make the decision that I thought was the right thing to do. Do you understand that?
Yes, sir.
Now, if I did put you on probation, it could be for up to 5 years of supervision. And as the judge, I would have the discretion to order a wide variety of rules or conditions for you to follow. One of those conditions could be an order that you serve time in the Lake County Jail up to 6 months as a condition of your probation. You understand that?
Yes, sir.
Further, if you're on probation and you ever violated any of the conditions of your probation, we would have a hearing to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I can impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I sent you to prison, again, in this particular case, it could be 6 to 12 months in prison, which could be consecutive to any other prison sentence you may be serving or that you're being sentenced to at that time. You understand that?
Yes, sir.
Lastly, when we do proceed to sentencing, you're going to have the right at that time to say anything you want me to know or consider. Your lawyer could speak on your behalf. He can recommend a sentence to the court. The prosecutor can also recommend a sentence to the court. Do you understand that?
Yes, sir.
Do you understand that whatever the lawyers have to say at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, sir.
All right, well, do you have any questions at all regarding the potential penalties you face by pleading guilty?
No, sir.
You understand all the possible consequences?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
You had enough time to discuss this case with Mr. Mulkey and have him go over everything with you?
Yes, sir.
Has he or anyone else made any promises to you about what's going to happen at sentencing which is inducing you to plead guilty?
No, sir.
Have you been threatened or coerced in any way to plead guilty?
No, sir.
Are you entering the guilty plea freely and voluntarily?
Yes, sir.
All right, do you have any questions for me at this time regarding anything we've talked about? The rights you're giving up, penalties you face, what you're pleading guilty to? Any questions?
No, sir.
Do you need any more time to speak with your lawyer before we go forward with the actual plea?
No, sir.
Then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the evidence would show if we had a trial. I want you to listen to her because I got some follow-up questions for you, all right?
Yes, sir.
All right, Ms. Johnson.
Thank you, Your Honor. The state would have shown that on or about February 24th, 2025, the defendant sold a trailer in Lake County, Ohio to Dustin Algier in exchange for $4,500. The defendant did know that he did not have ownership of that trailer or any property rights that would allow him to sell that trailer. It was sold with a bill of sale only. That trailer was then taken back from Dustin Algier by the Madison Police Department.
Thank you. Mr. Adams, were you able to hear what the prosecutor had to say regarding what she believes the facts would show if we had a trial?
Yes, sir.
What, if anything, did to say about those facts as she presented them? Are they true? Did you do what she said?
Yes, I did.
Very well. Regarding count 1, charging you with, as amended, with theft, the felony of the 5th degree, what is your plea to that count?
Guilty.
All right, I have in my possession at this time another document, 4-page document called a written plea of guilty and judgment entry, which sets forth everything I've just explained to you. Before I can accept your plea, I need to make sure you understand this document and that you sign it here in court. Now, I'm going to hand this back to you as well, because on page 2 I made several changes to reflect the amended charge and the different penalties that you face, which are actually less than what was initially in here. So, Mr. Shannon, if you can give this back to Mr. Mulkey. Mr. Mulkey, if you can review page 2 with your client and the changes that were made, please.
Since it was loaded, changed a few things in here. Okay, so you got an initial, everywhere you see blue ink here, all right? So it's one offense, so just initial there, certainly initial there, because now it's just theft. Right, there, right? Okay, here, out. Yep. I think that's it. All right.
All right, Mr. Adams, you had a chance to review this document, the amendments that were made,
Yes, sir.
and you've read the whole document as well earlier?
Yes.
You understand what it says?
Yes.
Any questions about anything that's set forth in here?
No, sir.
And what about the amendments? Any questions about
No, sir.
those? Mr. Mulkey, you did review this with him both earlier as well as just now with the amendments?
Yes, Your Honor.
And did he indicate an understanding of it to you as well?
He did.
You have any questions for me, Mr.
No,
Adams?
sir.
Now, it also appears you signed the document and then put your initials throughout the changes. Is that accurate?
Yes, sir.
Did you witness that, Mr. Mulkey?
I did.
Ms. Johnson, you witnessed the signature as well?
I did.
Very well, then, at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 1 as amended, theft of felony of the 5th degree in violation of 2913.02A3. I will incorporate the pre-sentence report that was completed in 26 CR 003. And with doing so, Mr. Mulkey, is there any reason not to go forward with sentencing?
No, Your Honor.
Is there anything you want to say on behalf of your client?
Yes, Your Honor, please. He is 48 years old. We've had several conversations together. He was very upfront about wanting to resolve the original charge for the aggravated possession and the obstruction and the theft. He acknowledged that he has a pretty severe substance abuse issue. When it came time for the new charge, for the theft, he wanted to resolve that one as well. I did have the opportunity to go over the facts of that case with him too. He was in full agreement that he committed that offense. Throughout his life, Your Honor, he's had a lengthy criminal history. I think it goes back to as early as substance abuse, beginning at age 7 with alcohol, from there to marijuana, cocaine, acid, opiates, Suboxone in prison, 2019, fentanyl, and he's indicated that he's never had treatment. He's asking for treatment. As to why he never got it on his own, I just think that he was in a place where he was just his life was so ruled by the substances that wasn't an option during any of his matters, and he would like the opportunity to take advantage of treatment. And to that end, Judge, he's been in contact with Aaron from our office, who's set him up. My understanding is for a Lake Geauga men's residential placement, if the court should allow. He has that game plan ready to go, and he would just follow all the community control orders, follow probation, and he wants the ability to show the court that he can do that even with this criminal history and with the substances that have ruled his life, that even at 48 years old, that he can demonstrate a change to lead a law-abiding life, and he wants to start that today, Your Honor. So we'd be asking for community control with placement and treatment. Thank you.
Mr. Adams, you have the right to address this court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yes, I'd like to say something.
Good.
A lot of my record from Florida, it's not. I'm not gonna blame the hand I was dealt in life. With
You're not
things.
going to blame what?
The hand that I got in life with suicides, my family, things like that. My son. I'm not blaming that. I made my decisions. I ran to Florida trying to run for myself. Lived in the woods for years down there, in and out, and I'm not a monster. They pretty harsh down there. They gave me 7 years for a theft charge, and while I was in there, my son died up here in Lake County. Shortly before I got out, and my whole life I've coped from 17 years old. The only thing I knew how to cope with was the pain, was to drink it away, and then it escalated to other things and other things and other things. And coming from a good family, I would work hard, and then what I'm starting to learn now from signature health counseling that I'm getting for the first time in my life is that this vicious cycle is, from ungrieved grief and a lot of things that I'm starting to learn about that I'm looking forward to learning more. But in Florida, I begged for help down there. There's no treatment opportunities down there. It's just locked you away for years, and I just never had an opportunity. I'm 48 years old now. I'm remarried, and I have 2 little girls that their father died from addiction. Some of this time is just, there's been a change in me. I've even sat and had a meeting with Officer Pitt in Willoughby. Him and I are going to get together. If I get the treatment, get through whatever the first part of that is, and he's going to go with me to some of these stores and let me talk to the loss prevention officers and let me help give my knowledge and my voluntary time, and then not tell people to get to the root issue. There's a way to give back. I'm looking forward to doing that. Just some changes. I'm just tired of it. I'm 40 years old, man. I'm just tired of doing the stupid stuff. It's just been I wrote an officer a letter immediately when I came in here because I felt stupid. I'm 40 years old running like a 15-year-old. Just time to grow up. I'm just tired of it. Just give me a chance. The treatment and the things, I'm not going to let you down. I can tell you that.
Anything else you'd like to say?
But that's it, sir.
Thank you.
Thank you.
Mr. Mulkey, anything else on behalf of the defense?
No, Your Honor, thank you.
Ms. Johnson for the state of Ohio.
Thank you, Your Honor. The state is recommending community control in these matters. The only other thing I would add to what's already been said is that the victim was informed of these proceedings and elected not to appear or provide any victim impact statement, but we did comply with Marcy's law to that effect.
You want the victim in the information case?
Yes, Your Honor. And I did speak as well to the officer who was injured for the same reason in the original case.
That's Officer Friel?
Yes.
I got a victim impact statement from him. That's the one we got, right, Kaylee?
Yes, sir.
This court reviewed the pre-sentence report and investigation. So the facts and circumstances of the offenses involved in both cases, the nature of the offenses. I've considered what's been said here today by the defendant, his lawyer, prosecutor. I received a victim impact statement in case 26 CR 003, and I've read and considered that. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-2911. As for the seriousness factors, I will note that in case 26 CR 138, victim suffered serious economic harm, $4,500 cash is taken from him. No factors indicate it's less serious in either case. As for recidivism factors, almost all of these are present. Defendant has a lengthy history of criminal convictions. It goes back over 30 years, 32 years now. And when you look at the record outside of time that he was in custody, there's offenses every single year almost. The gaps are when he was incarcerated. I've never seen theft record like this. Got out of prison in April of 04. In a period of time here, in 25, not 04, 24, I don't know how many theft offenses have been committed here or charged with. There's 9 outstanding warrants right now for the defendant. For failure to appear, for probable cause warrants. 9 warrants. He's previously served prison terms. He's failed to comply in the past with previously imposed sanctions ordered by courts. No factors indicate recidivism is less likely. I mean, it's guaranteed with this history. 29-29-13B1, the court finds defendants previously served a prison term. Prison is consistent with the purposes and principles of sentencing, and there's no way this court cannot impose a prison sentence. I don't understand how you don't think you should be punished and sent to prison with your history of theft offenses that have been going on for 32 years. In this last one, you stole $4,500 of cash from the guy.
Your Honor, can I speak?
No, you already had a chance to speak. Prison is consistent with the purposes and principles of sentencing. Defendant's not amenable to community control sanctions. He means he's a career criminal. Therefore, in case 26 CR 003, the sentence of this court that counts 1 and 2. Defendant served a term in prison of 10 months on each count and run those counts concurrent to each other. On the misdemeanor theft charge in count 3, I'll order that he serve 180 days. That's concurrent as well. He has credit in that case for 77 days he's already served. Case 26 CR 138. Sentence of the court, the defendant served a term in prison of 11 months. That's to be consecutive to the sentence imposed in 26 CR 003. There's no credit on that case. I need to advise you upon your release from prison in these cases, you may be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can send you back to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the prison term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Defendant's ordered to pay all costs incurred with both cases. Court's further going to order that in case 26 CR 138, defendant make restitution to Dustin Allgaier in the amount of, and Allgaier is ALLGYRE, in the amount of $4,500. Case 26 CR 003, restitution to Austin Friel in the amount of $300. I'm also going to order the forfeiture of the contraband in case 26 CR 003 pursuant to the specification in count 1. Lastly, the court finds that consecutive service is necessary to protect the public from future crime and to punish the offender. They're not disproportionate to the seriousness of his conduct and to the danger he poses to the public, and that his history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public from future crime by the offender. Ms. Johnson, is there anything else for the record?
No, Your Honor, thank
Mr.
you.
Mulkey?
No, Your Honor, thank you.